Driving while intoxicated, or DWI, in Texas is a serious offense with significant legal consequences. This video will navigate through the multifaceted landscape of DWI laws in Texas, providing a clear understanding of what constitutes a DWI, the legal repercussions, and the processes involved from arrest to court proceedings. We will also explore the implications for first-time and repeat offenders, particularly when a minor is involved, and discuss the specifics of administrative license revocation, or ALR. Texas law is stringent on DWI to ensure the safety of all road users. Understanding these laws not only helps in complying with legal standards, but also in making informed decisions about drinking and driving. This video aims to equip viewers with knowledge about the penalties, the legal process following a DWI arrest, and practical tips for prevention. Whether you are a Texas resident or a visitor, understanding these laws is crucial for responsible driving. The emphasis on DWI laws in Texas reflects the state's commitment to reducing accidents and fatalities caused by impaired driving. By the end of this video, you will have a thorough understanding of how Texas tackles DWI offenses from legal, procedural, and preventive standpoints. This knowledge is vital not only for drivers, but also for the general public to foster a safer driving environment. In Texas, a person is legally considered to be driving while intoxicated if they are operating a motor vehicle in a public place while impaired by alcohol or drugs, to the extent that their mental or physical faculties are significantly compromised. The legal blood alcohol concentration, or BAC, limit in Texas is 0.08%, 0.08 for drivers 21 years and older. For commercial drivers, the limit is even lower at 0.04%, 0.04. And for drivers under 21, any detectable amount of alcohol is grounds for a DWI charge. It's not just alcohol that can lead to a DWI charge. The use of drugs, including prescription medications, over-the-counter drugs, and illegal substances, can also result in a DWI if they impair a driver's abilities. For example, a person taking a prescribed sedative could face charges if it's determined that the medication impaired their ability to drive safely, regardless of whether the drug was legally prescribed or not. Furthermore, Texas law includes a provision for what is known as DWI with an open container. This law states that having an open container of alcohol in the vehicle's passenger area elevates the offense, potentially leading to more severe penalties. This underscores the seriousness with which Texas treats the issue of driving under the influence. The penalties for DWI in Texas are designed to be deterrents and are based on the severity of the offense and the number of prior convictions. For a first-time offender, consequences can include a fine of up to $2,000, jail time between 3 to 180 days, and a driver's license suspension for up to a year. These penalties escalate significantly with subsequent offenses, reflecting the state's zero-tolerance approach towards repeat offenders. For a second DWI offense, the fines can increase up to $4,000, and jail time can range from 1 month to a year. In addition, the driver's license suspension period can extend up to 2 years. For third and subsequent offenses, the individual faces up to $10,000 in fines, 2 to 10 years in state prison, and a license suspension for up to 2 years. These severe penalties highlight the escalating nature of punitive measures for repeated DWI offenses in Texas. Moreover, other factors can aggravate the penalties. For instance, if a DWI offense is committed while a child under 15 years old is in the vehicle, the driver can be charged with child endangerment, which carries additional fines and jail time. This reflects the broader implications of DWI beyond the driver's immediate legal consequences, emphasizing the potential harm to others, particularly minors. When a law enforcement officer in Texas suspects a driver is intoxicated, the initial step is typically a traffic stop. If the officer has reasonable suspicion that the driver is under the influence, they may conduct field sobriety tests. These tests are designed to assess the driver's physical and cognitive abilities, and may include tasks like walking in a straight line or standing on one leg. Refusal to perform these tests can lead to automatic arrest and further legal complications. Following a failed sobriety test or refusal to test, the officer will arrest the individual for DWI. The next step is booking, where the driver is taken to a police station, fingerprinted and photographed. Here, the individual may be asked to take a chemical test to measure blood alcohol content. In Texas, implied consent laws mean that by driving on Texas roads, drivers have consented to these tests. Refusal can lead to automatic license suspension and other penalties. During the booking process, the specifics of the charge are recorded, and the individual is held in custody until bail is set or a court appearance is scheduled. The bail amount can vary based on factors like the severity of the offense and the individual's criminal history. This initial custody can last from a few hours to several days, depending on various logistical and legal factors. Once charged with a DWI, the individual will face a court proceeding that typically begins with an arraignment. Here, the accused is formally presented with the charges and asked to enter a plea: guilty, not guilty, or no contest. Legal representation is crucial at this stage, as the complexities of DWI laws require expert navigation. Hiring an experienced DWI lawyer can significantly affect the outcome of the case. Call the Pink Law Firm at 713-664-6651. If a plea of not guilty is entered, the case will proceed to trial, where both the prosecution and defense will present evidence. The trial may be before a judge or a jury, depending on the specifics of the case. Throughout the trial, the defendant's lawyer will challenge the prosecution's evidence, which may include the results of sobriety tests and the arresting officer's testimony. Plea bargains are another aspect of court proceedings. In some cases, the defendant may agree to plead guilty in exchange for a reduction in the severity of the charges or penalties. This is often pursued to avoid the uncertainty of a trial and the potential for more severe penalties. The decision to accept a plea bargain should be made with comprehensive legal advice, considering all possible outcomes. Call the Pink Law Firm at 713-664-6651. In Texas, the penalties for a DWI can be quite severe, but certain factors can lead to even harsher consequences. If your blood alcohol concentration is 0.15, 0.15 or higher, or if you have prior DWI convictions, you could face enhanced penalties. These can include longer jail time, higher fines, and extended license suspensions. It's crucial to understand these enhanced penalties so you can fully grasp the seriousness of a DWI charge. When it comes to license suspension, Texas law is pretty strict. For a first-time DWI offense, your license could be suspended for up to 90 days. If it's your second offense, the suspension period could be up to 1 year. And for a third offense, you might be looking at a suspension of up to 2 years. It's essential to be aware of these details, as losing your driving privileges can significantly impact your daily life. Avoiding DWI charges starts with making smart decisions. First and foremost, never drink and drive. Plan ahead by designating a sober driver or using a rideshare service. If you find yourself in a situation where you've had too much to drink, don't hesitate to call a friend or family member for a ride. Remember, it's always better to be safe than sorry. Also, be aware of how alcohol affects your body and know your limits. By taking these precautions, you can help ensure you stay on the right side of the law. Facing a DWI charge can be overwhelming, but having the right legal guidance can make all the difference. An experienced attorney can help you navigate the complexities of the legal system, protect your rights, and work towards the best possible outcome for your case. Don't underestimate the importance of seeking professional legal advice if you're charged with a DWI. It's a critical step in ensuring your future and minimizing the impact of the charges on your life. So if you're facing a DWI charge, call the Pink Law Firm at 713-664-6651 now.